Welcome to the Jersey Justice Podcast, featuring your hosts, attorneys Gerald Clark and Mark Morris.
Anyway, Philip Nettl, thank you for coming on. And I want to welcome Mark back to the show. I think Mark's missed one or two. And just to prove to everyone out there, we're not just podcast lawyers. We actually are in court, which is why Mark's been away. But Phil, thank you for coming on. I was reading an article recently. I get all the decisions that come down from the courts, and there was a recent decision that came down from our New Jersey Supreme Court dealing with a client of yours that I think got arrested for allegedly abusing his baby. And apparently it was based on what I think the Supreme Court might have said was junk science in terms of there was medical reports about shaken baby syndrome. And I guess some medical professionals or something may have reported him for potentially abusing his child. And then he went through his whole criminal process. And there's been some huge groundbreaking new Supreme Court decision that's been put down on your case, and you argued. So that's why we asked you to come on to tell us about that.
Yeah, so I appreciate you having me. So the case you're talking about, my client's name is Michael Cifelli. So it's State versus Cifelli. There's a companion case. The defendant's name is Gerald Nieves. So it's Nieves and Cifelli are kind of go together. They'll have their names connected to each other for a very long time. But you're right. This Supreme Court decision was groundbreaking in the sense that, to my knowledge, we're the first Supreme Court or first state Supreme Court in the country to rule in this fashion that this kind of evidence is not admissible in court. But they didn't actually go so far as to say it was junk science. They just said it was unproven science.
Got it.
And they left the door open in a future case to still try to prove it if the studies are there to prove it. So for years and years and years, New Jersey used the Fry standard for admissibility of scientific evidence. And then just a couple of years ago, while this case was pending, we switched over to the Daubert standard. And so, but because this case was already in the pipeline under the Fry standard, which is, I know you have a lot of lawyer listeners. Fry standard is whether or not a scientific opinion is generally accepted in the scientific community, where the Daubert standard is more about testability and what the underlying data is to support the finding.
Subject to peer-reviewed testing, things like that.
So they left the door open that in a future case, if the state can meet the Daubert standard, they could try again to try to get this evidence before a jury. But for under the Fry standard, they said it was not scientifically reliable because it was not generally accepted in the biomechanical community, not the medical community. And that's so. Let me back up a little bit and tell you.
I thought this admissibility thing, though, it applies in what Mark and I normally do, which is civil cases. And I always thought the Fry standard was easier to get in scientific evidence, and that the Daubert standard became harder. But I guess the way you're articulating it and the court articulated is it's a different way to get it in evidence as opposed to one necessarily being easier or harder.
So depending on the context, it could be easier or harder.
Got it.
So the Daubert standard allows for novel scientific opinions to get in the door, even if they haven't yet been found or generally accepted. And it allows people to introduce new theories if the theories have been scientifically tested properly. Because you can't get to general acceptance on something that's novel or brand new.
Right.
So in that sense, it's a little bit more expansive. But under the Fry standard, it can also be restrictive in the sense that if something is not yet or has never been tested, yet is generally accepted, under the Fry standard, it could come in.
Got it.
So but what was going on here? So let me back up a little bit.
Yeah, tell us a story about your client, the facts, and what actually happened.
Sure. So as I said, my client is Michael Cifelli. He was a father of a 9-week-old baby boy, and there were 2 different incidents where the baby had to be taken for medical attention. The first time, he was diagnosed with viral infection. and that was in December 2016. That's how far back this case goes. And second time, and he was acting a little strange, a lot of vomiting, and he was taken to the doctor. Doctor diagnosed him with a viral infection, sent him home. Then about 3 weeks later, he had a set of immunizations, and then the next day, so my client, he was a cop at the time, and he worked nights. He would be home with the baby during the day, and when he came home, or when he woke up, I should say, he goes to check on the baby. Baby's in his crib, but acting very strangely, and he described it as seizure-like symptoms, where his eyes were open, but he wasn't really moving, and was just kind of glazed eyes staring off into space. Client freaks out, says there's something wrong, takes a video of it, sends it to the pediatrician's office via text message. He had the cell phone number of the receptionist in the pediatrician's office, did everything that you would think a concerned father would do. They then say, bring him in. He brings him in. They end up at the hospital. The hospital, they determined that he had an enlarged head circumference, which is indicative of fluid in the brain. They eventually performed some surgery to put a shunt in the baby's head, relieve the pressure from the fluid, and eventually were able to alleviate the symptoms. And the baby ended up being physically fine. But based on the examinations that were being done, they determined that the baby had not only had a subdural hematoma, subdural hemorrhage, which is essentially bleeding in the dural spaces of the brain, and had a set of retinal hemorrhages, which is a lot of broken blood vessels around the eyes. Based on those findings, they referred it out for an investigation into whether or not the child was abused, because historically, this idea of shaken baby syndrome is, they refer to a triad of symptoms. The triad of symptoms are subdural hemorrhage, retinal hemorrhages, and encephalopathy, which is some kind of altered mental state. And here the baby had all three. So then they referred it out to some child abuse specialists, who then came back and said, we have no other explanation other than this baby was abused, because that's what all the shaken baby science says. Now, at the time, there was no external signs of any kind of trauma. There was no bruising. There was no broken bones. There was no neck injuries. There was no head injuries, no skull fractures, facial fractures, nothing like that. The only symptoms that this baby had were internally within their skull. And they determined that abuse is the most likely cause. In addition, they found that when they went back, so they started doing this investigation, started talking to our client. He said, yeah, I was the last. He had nothing to hide. He said, yeah, I was the last one who was alone with the baby when the onset of symptoms. And so they took a statement from him. He denied doing anything wrong, said he was concerned.
Did they read him his Miranda rights at that point?
Yeah, they did.
Okay.
But he felt he had nothing to hide. As I said, he was a cop. He was just trying to do the best for his son. They took his cell phone, and they did a forensic analysis of his cell phone.
What police is it that are investigating this?
This is Middlesex County Prosecutor's Office.
Okay, got it.
Yeah. So they look at his cell phone, and they see the timestamp of when this video was taken. And then they see the timestamp of when it was sent to the pediatrician. They said, this guy waited 4 hours before he called anybody. He must have had something to hide. He must have had something that he knew they was doing wrong, and he didn't know what to do, and he freaked out for 4 hours. And so that was their whole theory.
Let me ask you a question real quick as you're going through the story. So how does he first get contacted by law enforcement? He brings the baby to the hospital, the treatment. Does the baby then come home? And is this days after?
No, the baby, once he brought the baby in for treatment, the baby stayed in the hospital for a few weeks.
Okay.
And it was the hospital that they reached out to. I think it was still called DIFUS then.
DCP&P.
Now called DCP&P. And they started the investigation. They got the prosecutor's office involved.
And then the prosecutors contacts your client.
Yeah, they come in, they start doing their investigation, they start talking to him, they start talking to...
Okay, so that's my question.
Sure.
Do you recommend people when that happens, even though the guy's like, I did nothing wrong, I have no, yeah, of course, come in. Do you recommend at that point they call you or another experienced criminal lawyer? Like, how does that work? Or once they do that, does the investigation get ramped up and say, this guy's lawyering up, he must be guilty?
So I think my recommendation is, yes, always call a lawyer, because you don't know what the ramifications are of any kind of interview with law enforcement. Now, there's different standards for when you're being interviewed by the police versus when you're being interviewed by DCP&P. There's a certain level of cooperation with DCP&P that's expected of you that because it's not a criminal investigation. It's an investigation into the best interest of the child and whether it's a child abuse case at all. And they can take action against you and open up a DIFUS investigation against you. And if you don't cooperate, then there's certain rights and privileges you could lose if you don't cooperate with the DCP&P investigation. But yeah, I always recommend people reach out to a lawyer because you just don't know. And you don't know, sometimes I know lawyers who will tell clients never talk to the cops.
Right.
I don't take that position because every case is different. And there are some times where I have sat people down and said, you got a story to tell. I cross-examine them as if I were an investigator. And if they hold up well and they think they're going to be a good witness, I'll let them talk. And a lot of times it can turn out well for them if they come in and tell their story.
But you're going to tell the story about the cell phone was what really triggered them, that he took the video and then 4 hours later he reported it. And you're going to tell us about that. There was a mistake there. But here's my question.
Yeah.
If he had called you right at that point when they contacted him, would the law enforcement had gotten his cell phone? Would you have turned that over? Would they have needed it, or could they seize it? And would this thing that you're going to tell us about have been avoided if he had called you right then?
I don't know if it would have been avoided. I honestly don't recall off the top of my head if they had a warrant for it or not. They probably did it. I believe he turned it over voluntarily.
Right.
And if he had called us, would I have told him to consent to turning it over? I might have actually in this case.
Yeah.
In this case,
go ahead.
But generally, I don't. If somebody calls me when they're in a situation like that, before I can give them any advice, I got to get them in my office, sit them down, talk to them, find out what's going on, find out what the investigation is about. Normally, I'll then call the investigator and say, what are we dealing with here? Does my client have anything to worry about? What are you looking at? And I kind of get a feel for the investigation before I can really give advice on whether to cooperate. If I know that somebody that they've already decided somebody has committed a crime and they're going to charge them, most of the time I'm going to say, don't bother talking. It's not going to change anything. It can only hurt you. But if I get the sense that it's truly a search for the truth, and I think that somebody's got a story to tell that is true, number one, and plausible and credible, then plenty of times I've advised them, yeah, I'll come with you. I'll make sure it doesn't get out of hand, but yeah, I'm okay with you talking to them. But
it's funny hearing that aspect of it because it's a lot of what we do. It's like, oh, it's not like you see on the movies, like on TV and stuff. But what you just said, the dynamic of like you're calling the investigator being like, hey, look, does my client have anything to worry about? Do I need to get involved? That does seem very like out of the movies and being like, yeah, no, it's time to lawyer up.
Yeah, and you do this long enough, you develop relationships even with the investigator sometimes. And they know they can trust you. You know you can trust them. And there is that level of professionalism that if they are really looking at your client as a target of some kind of criminal investigation, they'll tell you. And then that puts my antenna up. And I have that conversation with my client saying, listen, we don't want to give them the evidence that they're looking for if they're going to use it. Even if the person's innocent, but their story just, and I've had plenty of clients in this position also where they might be saying that they're innocent, but their answers to certain questions are a little troubling. And you don't want to give that information over if you don't have to, especially if they're going to charge your client anyway. But getting back to the cell phone. So as I said, they got really suspicious when they believed that he had waited 4 hours to call the pediatrician, but turned out it wasn't true. Turned out it was a time zone issue on a cell phone.
Is it like the UTC or something?
Yes.
They use some crazy. We've run into that.
Yeah. So they were going. The timestamp that was on the text message was Eastern, whatever, Standard Time or daylight. I was getting confused. But which is 4 hours behind the UTC, which used to be called Greenwich Mean Time. Now it's the Universal Time Code. But the timestamps on the forensic image of his phone, as far as when the video was recorded, were in UTC. So
he might have
been reversed.
He might have had a VPN on his phone, a virtual private network that was spoofing his location in a different location, different time zone or something. That's weird.
I know the records themselves because we run into that sometimes in like personal injury auto cases where they're like, oh, give us the cell phone records. You have to almost like decode it and like translate it from the UTC to the actual time period.
So, and I might be getting it reversed as far as which one was 4 hours ahead, but regardless, they did not line them up into the same time zone. And so this whole 4 hours evaporated into 2 seconds. Like he called immediately, or he texted the video immediately after recording it, which shows exactly what you would want to do, or what you would expect a concerned father to do when their baby's in distress. So they go and get this indictment, including the 4 hour gap. We point out to them, no, you got it wrong. They went back and looked at the forensics, and the prosecutor's office said, oh, shoot, you're right. We did get it wrong. And so they actually, at first, voluntarily dismissed the indictment because they realized that they screwed up, and they put some incriminating information before the grand jury that really shouldn't have been there. So, but then they still represented the case because in their minds, he was still guilty. And we're just going to take that one piece of evidence out, and they went and represented it to another grand jury, and they got another indictment.
And he was allegedly guilty of shaking the baby.
Well, that was always their theory, and because that was the only answer they could come up with
for the head injury.
Yeah, so to understand the whole shaken baby theory, so you have the brain matter inside your head, and there's the dura, which is kind of call it like some kind of an internal shell inside your head between your brain and your skull. And there's veins that attach from the brain to the dura. And so when you talk about subdural hematoma, you're talking about below the dura. And these veins that attach are called bridging veins. And the theory is that if you shake a baby hard enough, these bridging veins rupture and you just bleed into the subdural space. And when that happens, when you have those kind of injuries, they start searching for other potential causes of that kind of bleeding. And if they can't find any other causes, then, well, all right, it must be abuse. That's been their theory. And that's always troubled me as a defense attorney, somebody who believes in due process, burdens of proof. It's like, it's almost been, if we can't find anything else that might have caused this, then, well, it must be you abused them. Not that we have any independent evidence of abuse. It's not, no admissions, no witnesses, no other bruising, no recordings, no nothing. But because we don't know what else it could have been, and our doctors say, hey, these is consistent with abuse, then we're going to let them form the opinion that it's abuse, and we're going to indict you and try to take your child away from you. And so in my mind, it's always been kind of a reverse burden of proof. It's always kind of flipped the burden onto the defendant to say, it wasn't that, it was that. And that's always been one of my more systemic problems with it is just the idea of it's your burden to prove what happened, not mine.
Right.
It being the shaken baby syndrome.
Well, or the cause of the injuries in general. So getting back to my client, so they take the baby to the hospital and they see a neurologist. And the neurologist examines, this is the treating neurologist, not the child abuse examiner. And so the treating neurologist examines the baby, and she says, it could be abuse, but I'm not convinced. And one of the issues was, so when you think of it as shaking a jar of salad dressing or something like that, everything goes everywhere. But so usually when there is an actual shaken baby, you see everything is kind of diffused along throughout the brain. So you see these hemorrhages are in both eyes. The subdural hemorrhages are on all over. But in our client's case, the injuries are mostly unilateral, mostly on one side. So how does that happen from shaking? I never really understood that argument.
And it's not from punching because there was no external.
Right. Yeah. So then I guess now is a good time for me to explain the history of where shaken baby came from and how it ended up as a theory. So it started in the 60s. There was a couple of researchers who were in the biomechanics field who started doing experiments. There's one guy, Dr. Omaya, who did these experiments on monkeys that were the equivalent of like a rear end collision, and to try to measure what kind of damage that would do to their brains. And it was really the equivalent of a 30 mile an hour rear end hit, which is, you do personal injury law. That's
a heavy hit.
That's a heavy hit. Mm-hmm. A human being cannot cause that kind of external forces on another human being as a car going 30 miles an hour can. So, but based on his findings and some of the internal damage that he was able to find, he developed this theory that, hey, if you shake a baby, you might be able to cause the same damage. And then there were other researchers, when Dr. Gutkelch is one who's mentioned in the opinion, Dr. Caffey came later there, and they kind of built on that. There were some other experiments involving shaking lambs instead of monkeys. Obviously, you can't shake an actual human baby to do any kind of these experiments, but they tried to approximate it as best they could. And none of them were really ever able to prove that you could create the forces from shaking alone in any of these animals, as you could from a 30 mile an hour rear end hit in a motor vehicle. But they hypothesized it was possible, but nobody's ever able to replicate the actual results or confirm that this would be caused, that the human being shaking another human being could actually cause that so-called triad of symptoms. So, but it slowly became more accepted that this was a real possibility. And then the pediatric medical community, they were reading all these studies too. They have a responsibility to care for children, and their hearts are always in the right place. But they took this theory and became convinced that it was a proven theory. And so it became kind of gospel within the pediatric community, starting in like the early 90s, that you shake a baby, even if there's no other kind of impact, you shake a baby and it's going to cause this triad of symptoms. The retinal hemorrhaging, the subdural hemorrhage, and the encephalopathy. And it became really so accepted within their community that they tuned out people who were saying, well, wait a second, but the biomechanicists never actually proved this. And
so the biomechanists, so just give that this.
I keep getting that word wrong.
we run into that in personal injury stuff too, but so you have the biomechanist scientific community, and then you have the pediatrics, and you're saying that the pediatrics were establishing this shaken baby syndrome like you just described, but the biomechanical community did not.
They had never confirmed it.
And biomechanical is basically where they study the forces on a human body and what kind of injuries that can cause.
Exactly.
Yeah.
Exactly. So there've been a few studies over the years. I know researcher Christine Duhame, she tried, and she was skeptical in one of her studies. She later had another one where she kind of backtracked her conclusions, but she said, well, we cannot confirm that it would actually cause these results. So the biomechanical community never got to the point where it was generally accepted. The pediatric community, they said, we're taking this, we believe it, we want to tell parents they shouldn't shake their babies because this can happen. And by the way, they should tell parents that. They should absolutely tell parents don't shake your babies, because if there's even a possibility that that can cause a baby's harm, they shouldn't do it. I'm a father. I got 2 kids. You should always act in the best interest of the child, and you should not do something that has the potential of causing harm. Even not going to look at scientific journals to find out if you can shake a baby or not. But when you're talking about putting somebody in jail, when you're talking about proving that a father abused his child, it's got to be more than erring on the side of caution.
Right.
It's got to be proof that that person actually abused their child. So in the 90s, the pediatric community, they became convinced that this scientific theory was proven, and they started teaching all of their doctors to accept that this theory is proven and real and act accordingly. And they started putting out all these studies, consensus statements they put out to make sure that if it ever got into a courtroom, because there were a couple earlier cases, and I think there was even a U.S. Supreme Court case where Justice Ginsburg, in dissent, talked about the controversy about this diagnosis. And so they became very concerned that courts are going to start throwing out this theory. So they started to gathering their resources to put out papers after papers about the fact that this is generally accepted in the pediatric community.
They being who?
The American Academy of Pediatrics, and other similar organizations.
And what was their concern? That they wanted that to hold up in a court of law? That
essentially, yeah. I mean, they've put out papers saying if you get called to testify in court, these are the talking points you got to do in order to make sure that the judges don't throw out your opinion. But all of it was built upon those 1970s studies that had never been confirmed by further research. So it became this almost circular type of the building upon itself.
Yep.
And if you build upon an argument long enough, then it becomes generally accepted. And it was, but only among the pediatricians. And so then in our case, and there's a companion case, State versus Nieves, which is also, both our cases are out of Middlesex County, which is where I'm out of. And so we were in front of a judge on Cifelli, Judge Buca. Down the hall, literally the 5th floor of the Middlesex County Courthouse, is Judge Jimenez, who was hearing the case State versus Nieves. The Public Defender's Office, and I want to stop here for a second to give all the credit in the world to the Public Defender's Office, because they've been on this issue for a long time. They took the lead in some of these hearings that occurred, these evidentiary hearings. And so what happened was, I think it started in their case. So in front of Judge Jimenez, the Public Defender's Office, they filed a motion to challenge the scientific reliability of the shaken baby diagnosis. I should also say, I keep saying shaken baby, you keep saying shaken baby, because that's what everybody thinks of it as. So, the pediatric community actually has changed the name of it over the years. It's now SBS/AHT. AHT stands for abusive head trauma.
Yeah, I saw that in the Supreme Court opinion, because it kind of is a little like icky of a term to be like shaken baby syndrome in a scientific capacity.
It's like you're guilty just by saying what it is.
100%.
Yeah.
And I don't know if they changed the name because of the fact that it was icky, as you say, or if they changed it because there was some criticisms of shaken baby syndrome that were starting to become part of the mainstream. So they wanted to distance themselves from that. Or their answer would be, well, we changed the name because the shaken baby is too specific a name. It really is abusive head trauma because shaken is a common mechanism of it, but it's not the only one.
So just real quick, practically, how does this work? So your guy gets indicted, he gets charged, and then you get a packet from the prosecutor of discovery, and included in that is a report from a doctor they intend to have testify at trial.
Yes.
That says the medical evidence shows that he was abused by shaking the baby.
Yes.
Got it. Okay.
So
then you challenge that report and say it's based on junk science, or it's not scientifically, it shouldn't be admissible based upon the Fry standard.
Eventually, yes.
Got it. Okay. So,
again, this case is very old.
Yeah,
so a lot of stuff happened in
it.
between, and I don't know how boring you want me to get, but while this is all going on, so another attorney in my office, Joe Benedict, was He was actually originally lead counsel for Mike Cifelli. His show's mostly retired now, so that's why I got the pleasure of arguing this case in the Supreme Court. But so Joe, because there was DIFAS or DCP&B involvement in this, they filed their own complaint also. And there was a trial in family court on the DCP&P complaint. And in the family court trial, which is a bench trial before a judge, no jury involved. And it wasn't on the reliability of the diagnosis. It was just by preponderance, the evidence standard, was this baby abused?
DCP&P filed a case basically for what?
For abuse. Title IX.
To have the kid taken away from the dad, or what was the end goal with that?
Well, first, what they have to do is establish abuse. And then the remedy for that abuse is next level. But before they can even get to the remedy, first they have to have a trial to establish that the child was even in fact abused. And it's under Title IX, which of the New Jersey statutes, which covers child abuse and neglect. So they file this Title IX complaint, the Attorney General's office. And Joe tries the case. Our client's there. Attorney General's office is there. This Dr. Medina, who's the same doctor who testified in the Nieves case and was referenced in the Supreme Court opinion, she testified. Our doctors that we hired as experts, they testified. And after all of that, nobody moved to exclude any evidence, but the judge just heard it all because it's a bench trial. And she concluded that even by a preponderance standard, this child was not abused. And there's a couple different reasons that come up in some of the cases about what other kind of underlying medical conditions can sort of mimic what it looks like to be have a child be shaken and cause those same kind of triad of symptoms. I think in the Nieves case, there was, we talked about BESS, B-E-S-S, benign enlargement of the subarachnoid spaces, which basically what that means is if you got extra real estate in your skull, you can stretch out some of these stretch out some of these veins, and then takes much less force to cause the veins to rupture.
For the listeners out there, by the way, you see how difficult it is to practice law? Yeah. What you're explaining, and meanwhile you're fighting for a guy's liberty and right to keep his kid and talking about subdural hematomas, hemorrhages. But so anyway, sorry to cut you off.
So, but in our client's case, the theory, and again, it's not proving beyond a reasonable doubt, it's just an alternate explanation, was something called a benign hygroma, which is basically cerebrospinal fluid in the brain, which again stretches out the veins and can cause them to rupture with much, much less force than what it would even be incurred by shaking. So the treating neurologist, testified in the family court that she thought a hygroma was a strong possibility. She can't diagnose it, but it's a plausible alternative explanation for what happened here. Just
practically, are you subpoenaing that neurologist to come testify? What's the logistics of having that person come in to testify in a case like this?
She was... You asked me a question.
I think she was retained by them as an expert.
What? No, but she was treating.
Oh, treating.
She was treating, so she wouldn't have been an expert.
Okay.
We had other experts that we hired as experts. We brought her in, but she also did offer her opinion. So I don't remember the answer to that. I don't recall if she was paid to be there or not. I'm sure she was though, because she's a busy neurologist. Yeah. But the family court judge said, by a preponderance standard, this child was not abused.
So he's found essentially not guilty in family court, and
yes.
Now.
So then we go back to the criminal court.
Yeah, let's get even.
Then we file a motion to dismiss the case based on
double jeopardy,
collateral estoppel.
Collateral estoppel.
Law of the case, essentially.
Yeah, that you had same issues, same witnesses,
same
evidence, lesser burden of proof.
Yeah,
and we even argued that there was one of the prongs of collateral estoppel is privity, which is, and we say the Attorney General, Prosecutor's Office,
it's all
the same.
State entities of the state.
And Judge...
yeah, sorry.
And the judge, I disagree with the decision, but He denied the motion. There was some case law that said the family court cases in other contexts don't necessarily translate into collateral estoppel in a criminal case. So he denied it. So we had to go forward and continue. Meanwhile, this public defender files his motion in the Nieves case. We take a look at it and we're like, hey, that's a good motion. So we file it too. Ours gets the Judge Jimenez grants it in the public defender's case and schedules it for a hearing. Judge Buca denies it in our case and says we don't get a hearing on their admissibility of the shaken baby opinion. Then Judge Jimenez says, oh, wait, Judge Buca denied it? I'm going to deny it too. So then he denies it. The public defender appeals that. The appellate division reverses, remands it to Judge Jimenez, says, hold a hearing. So he says, okay, I'll hold a hearing. Judge Buca says, oh, wait, Judge Jimenez is going to hold a hearing? I guess we'll hold a hearing, but we're not going to do duplicate hearings. We'll just wait and see what happens in his hearing, and we'll abide by the outcome. So that all happened. Then they held the hearing in front of Judge Jimenez. We didn't even get to participate, but it was essentially the same witnesses we would have called, same witnesses they would have called. So we just kind of sat back, and then the Judge Jimenez, then after hearing all the evidence, hearing all from the, I'm going to butcher the word again, biomechanists.
I think. I'm not sure though.
And from the state only produced one witness, which was Dr. Medina, who was the child abuse specialist who diagnosed the abuse. And all the other witnesses were presented by the defense, who were all, there was the other pediatric neurologist, there was their biomechanist, there was Julie Mack, I forget what her specialty was. But the Judge Jimenez says state hasn't met their burden. Under Frye standard, we'll accept that it's generally accepted in the pediatric community. Dr. Medina was pretty clear on that. Nobody really disputed that. But Dr. Medina could not say it was also accepted in the biomechanical community, which are what a lot of the other witnesses were talking about. So he excluded the evidence. He dismissed that indictment. Goes back to Judge Buca in our case. Judge Buca said, okay, I'm going to suppress the evidence as well, but I'm not going to dismiss it right now. I'm going to see what happens when the state appeals it, because I know they're going to. So then the appeal starts. The state appeals Judge Jimenez, state appeals Judge Buca. Goes up to the appellate division.
And before all this, like, is it fair to say that many people in the state of New Jersey were convicted of abusing their babies based on the same kind of evidence, the shaken baby syndrome evidence?
It was a very common theory that was utilized by prosecutors' offices around the state and around the country.
Yeah.
You can't even limit it to New Jersey. They believed the pediatricians when they said this is abuse. And there have been a few cases. There was a judge up in Passaic County who had a bench trial, so that wasn't appealable because he acquitted the defendant. But based on the same theory, said it wasn't scientifically proven, he didn't accept it. And we had our two cases where they went up to the appellate courts to determine the scientific reliability. But there were other cases. I'm sure there's people who pled guilty. I'm sure there's people who went to trial and juries found them guilty. I don't have the numbers on that, but it was not uncommon. I've spoken to prosecutors in different counties around the state and say, yeah, we're watching this case because we have a couple cases in the hopper here that we're trying to see if we can go forward on them.
That was going to be one of my questions. Are there people sitting in jail that were convicted under this that are now going to go for post-conviction relief, or
like could it support a murder conviction too of a baby? Like, are there some where?
Oh, that was also. I'm in line with that too. I always assumed hearing that it meant that the child essentially died from that, but that's not
I guess
the
that's
case.
SIDS. That's probably more SIDS, right?
Yeah.
Sudden infant death syndrome.
Well, SIDS, as I understand, is when they don't know why.
Right. Yeah.
It just happened.
Yeah.
And that kind of ties into some of my concerns about shaken baby syndrome, is that sometimes, especially with infants, you just don't know why.
Yeah.
And I still remember sitting in our office with one of our experts and trying to figure out what happened to this baby and why this happened. And his words were bad plumbing. And it's just, if you have something going on with your vascular system in your brain that just, and we see it all the time in all different contexts, of some people just born with some kind of congenital issue that you don't really know why, or something, just a blood vessel bursts here or there, and you have an aneurysm here, and you don't, and I'm not saying that's exactly what happened here, but there's certain things that happen in medicine that you don't always get to a comfortable explanation for. So then to assume abuse because you don't have an explanation for it, that's always troubled me, because that goes to the heart of due process and proving somebody's guilt beyond a reasonable doubt.
I have to imagine when you meet with a client doing criminal law that you form your own personal opinions as to whether or not they did what they're alleged to have done or not. And I'm sure even along your career, even if you believe someone did what they've been alleged to do or not, you still have no problem representing them because the state needs to prove it. Due process is really important to a viable democracy.
Yeah, I mean, that's everything, really.
And so, yeah, maybe comment on that. But then, if you had any personal feelings about whether or not you think this person actually did the shaken baby, meaning did you think he was guilty or not? If you care to share any of that in this situation,
with regard to Michael Cifelli, I'll say this: I do not believe he shook his baby.
Right.
I think
all along the way, as you're looking at this stuff,
all along the way, from first time I had any contact with this case until today, I have not seen anything that would cause me to believe he shook his baby, and he has been steadfast in the insistence that this didn't happen. And circumstantially, the way he reacted to it, the way he behaved afterwards, I think is consistent with somebody who did not abuse their child. And I have no doubt in my mind that he's innocent of this. And I think as a more general principle, I think you asked, like, do I form opinions? Sometimes I do, sometimes I don't. I mean, it can be a dangerous thing to believe too much in your client's innocence, because one of my partners, Steve Altman, he's always said, like, if he ever writes a book one day, he's been doing this for over 50 years, and he said, if I ever write a book one day, the title of the book is going to be, Do I Really Look That Stupid?
Got it.
Because we hear all sorts of stuff from our clients.
Yeah. And you want to tell those clients, come on, do I really look that stupid?
Exactly.
Yeah.
And so listen, you take the clients as they come. We don't generally turn away anybody. If they want us to represent them, we can work something out as far as a retainer, and they are willing to follow our advice. I mean, we don't judge. Couldn't do this job if you started judging whether people are innocent or guilty. And there are some, but most of the time, if somebody wants to come in and tell you that they did something wrong, and there's plenty of people who come in and say, yeah, I screwed up, I did something wrong, or he had a comment, or whatever it might be, and in those cases, a lot of times you're trying to get the best result for them with a plea, sentence, whatever it is. When somebody comes in and says, this just isn't true, I just didn't do this, well, then that's the approach that you have to adopt. And you don't sit there and judge, well, are they lying to me? Because it doesn't suit their purposes. I mean, at this point, I have to accept the client, that I have to accept what they're telling me. I'm going to do investigation, and the investigation that I do is going to be so that I know how strong the case is, so that I know if there's anything my client's telling me that can be easily disproven by the state's evidence, then I got to have a real heart-to-heart with my client about that.
And even if you think they're quote-unquote guilty, or they've admitted it to you or something like that, first of all, those admissions, all that's protected and privileged, so you can't tell anyone.
Yeah.
But then secondly, even under those circumstances, you as an attorney have an ethical and professional duty to give them a competent defense and hold the state to their people. Don't, a lot of people, non-lawyers, don't realize that. If you want to just comment on that, you know?
Yeah, and I think this is probably the most. So I in addition to practicing law by day, I also teach in the evenings at Rutgers in the criminal justice program for undergrads. So I field these questions a lot.
Yeah, that's why I'm asking you.
From students.
That's why we asked you to come on.
Yeah.
You know,
But they want to. I always get asked, like, number one, how do you defend somebody who's guilty? Number two, what do you do if somebody tells you that they're guilty, even if you still are able to defend them? And so many people say, well, isn't it your job to just get up there and lie?
it's terrible that the public thinks that.
No, they do.
No, it absolutely is. That's why I kind of jumped in half joking around, but being like, see how hard it is to be a lawyer? That, the conception is like, aren't you just a liar? You get paid to lie?
Yeah.
It's
No.
not true.
It's not true.
Yeah.
And
in fact, it's against the law for us to do that. It's
100%.
unethical, and we could have problems with our law licenses if we're knowingly lying or something.
yeah. And not just with the licenses, but you'll never have a judge trust you again. You're never going to have a prosecutor trust you again. And a lot of what makes good lawyers is being able to build those relationships with colleagues. I don't think of prosecutors as enemies or adversaries. I think of them as colleagues, but we're on different sides of the same coin. We're both trying to get justice. We just have a different view of what that might look like in a particular case.
It's funny. We talked a bit beforehand. That criminal law, that was my experience with the dynamic. That, hey, look, we both have a side to represent. We're doing our thing. With civil, so often it seems so much more litigious, and you're not that's not the right word, contentious, where you're fighting over, and you're dealing with money, oftentimes insurance money. But criminal, you're dealing with people going to jail or not. But there's such a more camaraderie.
The dynamic's
aspect to it.
different because in civil law, it's our job to try to win the case within the bounds of the rules and the ethics and everything. And it's the job of the defense lawyer to win the case within the bounds of the ethics. But in the criminal defense versus the prosecutor, the job of the prosecutor is not to win the case. It's what?
It's just to do justice.
Yeah,
and that's right in the law. So if the prosecutor knows they're innocent, or there's exculpatory evidence that leads them to show that they're innocent, they have a duty to produce that and turn that over, right?
Oh, absolutely. Yeah, Brady material, Brady v. Maryland, anything that's in the prosecutor's possession that tends to prove a defendant's innocence. Due process requires you turn it over.
That's a great point. That's a great qualifier. As a prosecutor, your job is to do justice and represent the state's interest,
not to obtain convictions.
Yeah, exactly.
Yeah, and a lot of the general public thinks, well, that's what prosecutors do, but the really good prosecutors are the ones that are able to see the difference between the people who need to be prosecuted to the fullest extent of the law. And there's plenty of people like that out there, but also the ones that there are mitigating circumstances there. There might be holes in the case that may cause them to want to try to work something out that's more favorable to the defense. And it gets harder when you have victims involved because victims, they see their loss, whatever it might be. If they were assaulted, abused, if they lost a family member to a homicide, something like that, victim's never going to be made whole, no matter what the prosecutor does.
Yeah.
So they're going to, most of the time, victims are going to want as much as possible out of the court, out of the defendant, out of the prosecutor. But the experienced prosecutors can look at those situations and say, yes, but it doesn't fit within the confines of how we treat these kind of cases. We do a lot of vehicular homicide cases in my office also. And those are, in my opinion, the most difficult kind of cases to handle because 99 times out of 100, you have good people on both sides. You have people who maybe had too much to drink, maybe drove a little recklessly, but were not out intending to hurt anybody on one side, but they made a terrible mistake. And on the other side, you generally have completely innocent people who did not do anything to put themselves in that position. And though family members of those people are understandably devastated by their loss. But you're never going to make them whole through anything a court can do. And so you have prosecutors have to work out plea agreements and that kind of things with defendants in those situations that a lot of times are not what the victims want. And the experienced prosecutors, I think they can understand how to deal with those situations in order to explain to victims and their families, hey, this is not the right case to ask for a life sentence. It's just not you're never going to get it. And this is somebody who's not a murderer. And it's hard for a lot of people who've lost somebody to understand that not every homicide is a murder.
we can talk, you can talk about those lofty kind of ideas where the prosecutorial discretion and, the good prosecutor knows not to push too hard on this one or that one. But at the end of the day, doesn't the prosecutor have a lot of power? And isn't there really a lot of power there in terms of who they can choose to prosecute or not? Like, I remember I had a client years ago who, it dealt with like insurance fraud or something, and the prosecutor's office was prosecuting insurance fraud. And the person heard that they knew someone in the prosecutor's office, and literally the file had been hanging around for a long time. And one of the subordinates was like, okay, what do you want to do on this? And allegedly the prosecutor said something like, oh, that guy's an asshole. Yeah, prosecute him. Go after him, So, I mean, in the real world, isn't there some sort of like, power dynamic to that? And isn't it kind of crazy sometimes, like who gets prosecuted and who doesn't? I mean, sure, if you have a murder or a thing, but when you have these more white collar things or more complicated things,
I mean,
I don't know.
The prosecutor has enormous power because of the consequences of just charging
a
someone.
charge.
Of course. Yeah.
I mean, just especially when you're talking about something serious, something that's going to come with some mandatory prison time, then all of a sudden the person that you charge, their life gets flipped upside down. Sometimes they deserve it, sometimes they don't. But you have to understand the power that you're wielding there when you decide to charge somebody. And yes, if you have a violent case or a drug case or something like that where it is what it is. But in those kind of more paper cases, the white collar cases, a lot of times those people are going to be, up until that point, a law-abiding member of society who has a family and a home and a good job, and maybe they were embezzling, maybe they were defrauding somebody, we don't know. But you have to look at it very carefully because you have to understand that you can't unring that bell once you charge somebody.
I've also heard things like in terms of some kind of commercial cases where, maybe someone's building a house and they think that their contractor defrauded them or something, and then the person, might be well-to-do and has a contact at the prosecutor's office, so they get that, and then the prosecutor gets on it and goes after him. Again, it's not like a thing where there's any blood in the ground, but it's more of a complicated commercial thing. I've heard that stuff too.
I've seen a few of those cases where the contractor takes a down payment, starts the job, and then just never comes back.
Yeah.
And then the homeowner's sitting there like, wait, what happened here?
Yeah, and that can go.
And I've seen those cases get prosecuted. I've seen sometimes they go after them civilly.
Yeah.
But those happen pretty frequently.
I remember my short time at the prosecutor's office, there was a Hurricane Sandy task force because that was so prevalent back then that they were really keen kind of into that.
Yeah.
All right, you want to get back on
It's just
track
that
and
you
tell about
Jerry too, basically about just like the right to a defense and things like that. I don't know if you finished your answer to Jerry's question
I'm
before.
not sure if I remember what
like
my
you're
answer
talking
was
about
at this point.
as a professor, Jerry asked about your right to defense and how you explain that to the kids.
Yeah, how do you explain to somebody?
I mean, I guess the short way to do this is okay. The cops or the military, whatever it is, and they say, well, that's clearly a drug dealer and they're clearly running drugs, so we're going to blow them out of the water, and then they're clinging to a raft, and can we blow them out of the water again? And the idea is, we spend so much time and money, taxpayer money, prosecuting people, putting them in jail. Why don't we just have like the cops, if they know they're a drug dealer, just immediately arrest them, convict them right behind the police station, and give them whatever the appropriate punishment is? Why don't we just do that? Isn't that a lot more efficient way to handle things?
So
what do we need all this due process mumbo jumbo for?
My father grew up in communist Czechoslovakia, and that sounds like something the communists would do. And that's my shortest answer to that.
Do you mean striking the boat twice, or do you mean bringing him behind the police station?
Deciding that somebody's
flagged.
I know.
Deciding that somebody committed a crime, and then just going and snatching them up because they decided.
Yeah. Why can't we just have one department that's judge, jury, and executioner? Isn't that a lot more efficient?
Sure, it's efficient, but it's not just. It's not fair. I mean, everybody is
Obviously, I'm being facetious.
I know.
Just in case I happen to run for some office someday, they'll take that snippet.
I know.
Not watching the video.
Yeah, I know. It's rhetorical, but but that's kind of why I do what I do, and I even use the example. I talk about my father. He was growing up. I think when my father was 12 years old, the communists were in charge, and they took my grandfather and locked him up for 2 years because he was, before communism took over in 1948 in Czechoslovakia, he had a couple businesses. One of them was he sold furs. And when the communists took over, they controlled all businesses. And so you weren't allowed to have a private business. And so they found out he was black market selling these fur coats or whatever it was. And so they said, you're going to jail for 2 years. And I think that has, I can't say it's always stuck in my head, but it's just the idea that somebody could just be snatched up and taken away because somebody makes an accusation against you. Somebody was trying to enforce a law that just doesn't even make any sense.
What about snatching them up and taking them away because they look different? Maybe their skin's a little dark. Maybe they look like they're from Central America. Should we be doing that in America?
Yes, me, of course not. I mean,
being a lifelong criminal defense lawyer.
I mean, so my
not lifelong, but it's your career.
No, but my office in New Brunswick, we have a lot of Hispanic clients. New Brunswick is a very diverse community with people from all sorts of different countries. So, I mean, if you could use somebody's ethnicity as reasonable suspicion or probable cause to even detain them, forget about arresting them, just to even detain somebody because of the color of their skin, well, then where do we go from there? I mean,
that's a great point.
It's, and I see some of the, you're going to talk about ICE raids or that kind of thing. It's, if you're using the fact that somebody might be part of an immigrant community and people in that immigrant community might not have papers, and you're using it as a reason to just sweep everybody up and then check their papers, it's a very slippery slope from there, in my opinion. I mean, if you're investigating a particular crime where the witnesses say the person who committed the crime is Mexican or whatever, and then that is a legitimate justification for seeing a suspect on the street who happens to fit that ethnic profile and say, okay, we at least have one piece of the puzzle he fits. Does he fit the others? And if so, we can use that information to detain him and question him. That's fine. That's police work. That's using the information available to you about a specific offense. Or if you have information in the immigration context, if somebody is here, they've overstayed their visa, or they have a detention or a deportation order that they ignored, and we find that person and pick them up, okay, fine. They defied a court order. They're committing a crime. You can pick them up. Got no problem with that. But if you're going into back of restaurants, car washes, where you know a lot of immigrants work, and you know that some of them tend to be without their papers, and just you do a raid based on that without any more specific information, that I think raises serious questions for me.
Yeah, and when you talk about the slippery slope, it reminds me of like that Pink Floyd song from Pink Floyd, The Wall. You know, look at that guy.
I'm a huge Pink Floyd fan.
What's that?
I'm a huge Pink Floyd.
Yeah,
so I was waiting to see where you're going.
So you know what I'm talking about? Like, you know, that guy, he looks suspicious. Put him up against the wall. You know.
Yep.
And that guy, he don't look right to me. Put him up against the wall. You know, like, is that the kind of society we want? You know, and I think what people should appreciate is that what you do for a living, you could sit home and just hang out, but you're working hard. You're going to court. You're running around trying to support people's rights, and you're pushing back against that kind of state power, like you did in this Nieves case, in terms of using this, what I'll call loosely junk science to convict, you know, God knows how many people and everything. So I think that's important, that people understand the place of a criminal defense lawyer in a thriving democracy.
Yeah, I mean, it's easy to question why somebody would want to stand up there with somebody who's accused of doing something horrific. And I understand that. And I might question it too if I weren't in that position. But I get satisfaction out of knowing that somebody who not only has a presumption of innocence, but is somebody who might even have a legitimate defense that other people may not understand, that to be the one who's standing with them and being the only one to speak for them when nobody else will. Like, and once in a while it works out. Being a criminal defense lawyer, you got to get used to getting kicked in the teeth a lot. But when it does work out, it's pretty satisfying.
So let's take it like to the extreme though, and talk about whether or not the ends justified the means. So I've been to El Salvador like twice, okay, and this was years ago, and we got picked up at the airport. Looked like a nice country to me. I'm driving to the place where we were staying, and I asked the driver to stop, and can we go check out this market? And he was reluctant, but we stopped. And he's like, all right, let's go. Like, he didn't want to stop. He wanted to go. We finally get to the place, and there's a guy with a shotgun at the entrance to where we were staying. He's looking around, opened the door, rushes us in. My point is, El Salvador was a super dangerous country. And apparently what they've been doing over the last couple of years is arresting anyone with suspicious tattoos, okay? And I was talking to someone that was in El Salvador relatively recently, and the government came into a bar, took every male. They lined them up outside. You had to disrobe. They checked your tattoos. Depending on your tattoos, you got whisked away. But now, apparently, El Salvador is like one of the safest countries in the Western Hemisphere. But I guess a lot of those Eastern Bloc communist countries were super safe too. You could walk around those countries and no one's ever going to rob you or mug you. So,
well, yeah, because nobody had anything to steal.
I guess so. But I mean,
y'all fighting over the same bread?
Yeah, I guess that's true. I mean, so are there some situations where the ends justify the means, or I mean, I don't know. What's the answer to all this stuff? Did you think you'd have such deep questions coming into this today?
I was gonna say
it's a legitimate question. I mean, I don't think the ends always justify the means. I think certainly, yes, if you have a completely authoritarian country where people are afraid to leave the house, they're not going to be fighting each other, robbing each other. They're going to be more afraid of the government than they are anybody else. So you're just picking a new enemy. And if you have a society where everybody is afraid of government knocking on their door, is that better? I don't think so. My personal opinion, I think that we throw around words like liberty, justice, Superman, and all that, liberty, justice for all. But the idea of liberty, in my opinion, means liberty for everybody to live their lives free from government intrusion, unless they do something to deserve it. And we have these principles set up in our Constitution, and I'm a big believer in the Constitution. Maybe I have to be because of what I do, but it's also something that I've developed over the years that I really see the value in it. Now, does that mean that sometimes bad guys go free? Yeah, it does. And do we want to live in a society where it's more likely for a bad guy to go free than for an innocent guy to go to jail? Bad guys go free every day just because they never get caught. And we accept that. An innocent person in jail, to me, is much more of a tragedy. Because if a bad guy goes free, you can keep on trying to catch him.
Yeah.
You can keep on trying to get evidence on him. But if an innocent person goes to jail, who's standing up for that person? And who's proven? Because I always think back to the Franz Kafka book, The Trial.
I have in my note to bring that up because that's what I've been thinking about the whole time you've been talking. Do you ever have to read that? Do you ever read it?
I use the phrase Kafkaesque often in describing the way defense lawyers present bad defenses in our cases, but I haven't actually read Kafka's book.
Kafka is also Czech, by the way.
Okay, there you go.
I'll give you my copy if you want to borrow it, because honestly, it's what you're talking about.
Because God knows I don't have enough work to do as it is.
Seriously, one of the flights or something.
It's a relatively thin book.
But when you get through the end of the year, have some time to decompress, take a read.
I will. I'll definitely mark.
All right.
I think every lawyer, especially criminal lawyers should read that book at some point in their lives, along with To Kill a Mockingbird. But the
Another favorite.
And watch the movie 12 Angry Men. That's a great movie about a criminal jury.
Yeah.
And that's on my list. I have to watch that. So
Yeah,
I'll
that's
do
a
that.
good
I'll watch that.
Watch the original.
But yeah, Kafka, not giving anything away about the book, but basically the guy wakes up, he's been convicted of a crime, he doesn't know what it is, and he's just trying to find like his way into the court system, and it's just this Kafka-esque nightmare of going to this place and that place, and he's like, what has happened? What is going on?
But I think that speaks to the whole idea of why we don't require people to prove their innocence.
Right.
Because proving your innocence means proving a negative.
Yeah.
And proving a negative is not only when you don't even know why you're being charged, but also when the state has all the resources, the investigative resources to collect all the evidence for the most part. But also just the idea of proving a negative in general. Like, how do you prove that something didn't happen? And I think that is the explanation for why the burdens of proof in our system are set up the way that they are. That somebody's presumed innocent doesn't mean they're factually innocent. It means that they're legally innocent until that burden shifts in the courtroom. And I think without that burden, without that presumption of innocence, essentially it leaves it up to the discretion of policymakers, cops, prosecutors, judges to say, we think this person did something wrong and they should be punished, and who's to stand up for that person?
So I don't know if it's just my feed and it's rage bait popping up in my feed, but, you know, there's one where this girl's running down the street, you know, in Florida. She looks Hispanic, I think, and she's screaming like, leave me alone. It's the most heart-wrenching video. And there's these like fat, overweight, like thug-looking guys running after her, like, and she's like a citizen, you know? And then there's another, maybe it's the super exception and I just have a lot of rage bait showing up in my feed. But then there's another one where there's like a nurse and she's getting accosted on the roadway and thrown down. She's like, I'm a citizen. What are you doing? Like, and then they're pointing guns at everyone. I mean, is that shit showing up in your feed? And does that kind of thing concern you? Like as a defense lawyer who lives by the Constitution and speaks for people that can't speak for themselves?
I mean, it's hard without knowing what the context
the
is.
The full context, exactly.
Of those videos.
Exactly.
I mean, listen, there's plenty of times where people are being arrested for very good reasons.
Yeah.
And people are being chased down the street by cops for very good reasons.
And if you just see it isolated, it can look like very upsetting, but it's justified.
Yeah, I don't trust anything online
right.
anymore.
That's probably smart.
Deep fake AI.
Yeah.
Yeah. I mean, even if it's not, it's just everything that you pick these clips out of context and you don't know what led up to it.
What is the due process element of what Jerry's talking about, that stuff? Is the argument now that, hey, they're not even entitled to due process? Because I heard something the other day where there was an argument that, and you told me from day one when we sat down in a professional context, the Constitution protects people in the United States. It's not just citizens, it's people in the United States.
All men.
That their argument is they're not entitled to due process. You know, they go defend their own country's constitution if they want due process.
Even though immigration it's a civil violation, it's not a criminal violation. Still, it's the due. And I'm not a criminal lawyer, but I'm going to jump in and see if my answer's right, Professor. You could tell me. Do they call you Professor Nettl in school?
Some students do. I try to discourage it.
Oh, really? Okay. You look like a professor.
It's Mr. Professor Nettl.
Yeah. No, but
Doctor.
But I think the due process clause, because we have two constitutions at work in our context. One is the New Jersey State Constitution, and then we have the United States Federal Constitution. But I think the due process clause, it's the search and seizure clause. You can't pull someone over without probable cause. So even though it's an ICE raid and chasing the little girl down the street, the probable cause can't be the color of her skin.
No, and that's again why my short stint in the prosecutor's office. I mean, that's like criminal law 101.
Because
was it Terry stops and things like that?
Yeah, Terry talks about reasonable suspicion for any kind of investigative detention. Due process was. Don't mean to correct you on your podcast, but
you correct me all you want.
So due process,
14th Amendment.
Due process is
spewing a lot
federal
of BS
due process
here.
is the Fifth Amendment. State due process is the 14th. You cannot deprive somebody of life, liberty, or property without due process of law. Search and seizure is a force, so it's a little different. But still, that's where the probable cause comes in. So
both are the clauses from which the right to privacy was gleaned from the penumbras
penumbra.
of the Constitution until a few years ago when
until
that right to
Dobbs.
privacy was very much.
Yeah.
But anyway, go ahead.
The penumbras don't exist anymore. But
Yes.
But yeah, so due process means that somebody, life, liberty, or property, if you want to take it away from somebody, you have to give them a chance to know why and contest why. That's essentially what due process. It's a process that anybody would have if you're trying to. This is kind of a circular definition, but you have to have your day in court essentially, and they got to establish why they're doing what they're doing. And I think in the beginning of the most recent presidential administration, they started just putting people on planes. I think for the most part, judges put a stop to that by now. And
That's good to hear.
And
Yeah, it is good to hear.
and even people like this, the guy from Maryland, Kilmer Abrego Garcia, who was wrongfully deported, they eventually got him back
To El Salvador.
to El Salvador.
To El Salvador, by the way.
Yes. And they eventually were able to get him returned. And then they brought him up on some
Picked him up again.
federal indictment, which was practically laughed out of court by the judge. But
Also
yeah,
good
so
to
the crux of it is, yes, he was entitled to due process. And people who are put into immigration proceedings are entitled to due process, regardless of where they came from, regardless of, I mean, if you talk about somebody who's an illegal immigrant, first you got to prove that they're an illegal immigrant. You have this person walking down the street.
Yeah.
Are they somebody who has a green card? Are they somebody who's a citizen? Are they somebody who's here on a visa? Or are they somebody with no papers at all? You got to establish that baseline before you can determine what to do with that person.
I prefer to call them undocumented immigrants or more preferably aspiring Americans. I definitely don't like to call them illegals because I don't think anyone should be deemed a quote unquote illegal. I think it's just
right. And I actually I agree with you. I was using without papers before. It's called them illegal immigrants. I was using the terminology that the administration uses. But yeah, I agree with you. I mean, people are people. And if you want to tell somebody that they have to be removed from the country that they call home to go to another country, maybe they called it home at one point, maybe they didn't. People are being sent to countries that they've never been to before.
I saw some story, and again, it's the same thing. I don't know if I'm getting fed rage bait or whatever. I saw somebody got picked up like that, and they sent them to some country in Africa that he'd never been to because he's not a threat there. He's from somewhere in South America, and they're like, we'll just set him up there.
Yeah, so,
which is like we're back to like almost colonial time, like 1800s, where it's like we're sending these people here.
And
I might get sent to Ireland at some point. I don't know if I keep talking.
They'll split me into 30 pieces.
Yeah, exactly.
Scotland, Ireland, Dutch, German.
Exactly. Exactly.
Yeah. I mean, I'm not an immigration lawyer, but my understanding
you're going to Czech. Sorry, buddy.
Yeah.
You're in
That's
Czechoslovakia.
It's beautiful. You ever been to Prague? It's awesome. I was just there last year.
Actually, Mark, you're getting sent to like Plymouth, Massachusetts, isn't that?
They're sending me back on the
came
Mayflower. The Puritan.
Exactly.
So my father
Where are they going to send the Native Americans? They're going to like send them to reservations out in Colorado? Like,
I think that
I don't trust ICE to get it right, regardless.
Oh, it is a crazy dynamic, but
when you have somebody who's here on an asylum case because they're afraid of whatever country they're coming from, afraid of persecution, and then the government says, well, they're not allowed here either, our laws say, well, they can't go back to where they're going to be murdered or persecuted. So you got to send them somewhere else. And that's why they're picking these African countries. They've agreed to accept them. And it's just, then you're sending some people, not just they don't know the language, but they have no idea what's going on in that country.
Reminds me of the scene in Godfather 2 with Hyman Roth in the airport, and he couldn't find a country to accept him.
Yeah. No, it's...
All right, should we get back on track and tell us
should.
about this Supreme Court case?
One more but it's back on track on this case. So your client, Michael Cifelli, is he married? Does he have a partner, someone raising the kid with him at that time?
So I was telling Jerry this before. I told
and you don't need to.
I talked to my client about coming on the podcast. He's fine with it, but I promised him I wouldn't talk about anything personal.
Okay,
that's going on with him outside of what's public information.
Totally got it.
So I'll leave it at that.
All right, that's fine. coming into it, we talked beforehand
Yeah.
as well. I have a young kid, and this kind of hits close to home, so I totally respect.
Yeah,
that.
no, and I just want to maintain his
Yeah,
privacy
of
as much as possible. He's what I will say is the last 9 years now have been just hell for him.
Because that's my first thought. Like, if you're innocent and they're like, okay, your kid's sick, your kid's injured. Oh, and by the way, we're charging you with abusing your child. You might be going to jail, and hey, now you're in this Kafka world where you've been charged, and that in and of itself is,
Well, that's why I say even when this kind of thing happens, even when you win, you lose.
100%.
There
But
was
go ahead. You want to pick up the story and tell us what as you're going along and ultimately winning this case?
so we end up in we went in the appellate division. The appellate division affirmed Judge Jimenez's ruling. It was a published opinion, so we hoped it would end there, but it didn't. The state appealed to the Supreme Court. Supreme Court accepted cert, and they agreed to hear it. And we argued that case October of last year, 24. We didn't get a decision for 13 months after that, which tells you they spent a long time going through the science, and there was a lot of amici who submitted briefs on this who really helped out on both sides.
Yeah.
And then we got the decision.
Tell us about your argument, though. Like, you showed up in the Supreme Court, you argued. Had you been there before? What'd you do? What was your strategy? How'd you prepare?
So my strategy was let the public defender do all the heavy lifting.
Yeah.
And then I mop up at the end.
Was it intimidating? You're standing there before, what is it, 7 or 9 justices?
7 in the state Supreme Court.
Yeah.
I've been
You've
there.
argued there a couple times, Jerry.
Yeah.
right?
Yeah. Just
I've been there before. In fact, one of the very first trials I was ever involved in as a lawyer was a capital murder case out of Middlesex called State versus Beretsky. You could probably look it up because it ended up in the Supreme Court on an interlocutory appeal on a Miranda issue. And I got thrown into it, and I was like, okay, cool, I'm in the Supreme Court now. I was second chair in that case. Like I said, it was my first trial, but I got to argue a little bit. And that was a lot of fun. But we ended up losing the issue. And I think, I'm trying to think, have I been arguing in the Supreme Court between then and now? I don't know that I have. But because I didn't have the real meaty part of the argument, as I said, the public defender, they had the record and they had the hearings in their case. I didn't. So I was able to just we worked together. Cody Mason did an amazing job. And we prepared together and we talked about the case a lot. But when we got there, State argued, Cody argued, I came in and I argued. But I was much more relaxed, I think, than I even expected to be. Because by the time I got up, most of the issues are already pretty well fleshed out. And I got to not just read the justices' responses to some of the arguments, but I also got to get a sense of what they were interested in. So then when I got up, I was able to just I don't script anything out when I argue. I have bullet points. I have points that I want to make, but I don't script out what I'm going to say. Because I like to react to what I'm seeing before me. And so I got a sense of what issues that they were seeming to focus on with some of the other lawyers who had argued already. And so I kind of tried to hit some of those points. And I don't know how much anything I said really made a difference in the end, but it was a great experience.
But being a smart and experienced lawyer doesn't necessarily being the center of attention, the, crazy winning arguments, but reading the room and knowing what to say and what not to say. Sometimes the best lawyer, the smartest lawyer will just shut up or know when to shut up and not say anything.
Oh, yeah. I mean, you really want to know. I like the expression, you don't want to snatch a defeat from the jaws of victory.
Exactly.
Yes,
That's a good one.
Yep.
And sometimes I had some silly municipal court case recently where I was on Zoom and it was a judge that I'd been in front of a million times, and whatever the allegation was ridiculous. And the complaining witness gets up there and he says what he's got to say, and the judge, I could tell just from his facial expression, he wasn't buying any of it. And so before I even said a word, he's like, all right, dismissed. And he says, Mr. Nettl, brilliant as always.
That's what I'm talking about.
And I'm like, all right, thanks, Judge. I'm out of here. But yeah, I think especially for lawyers. I mean, we've been talking for an hour and a half now. Probably we love to talk. We love to hear ourselves talk.
Exactly.
To know when to shut up is a real skill.
Yes.
That a lot of lawyers can really think about focusing on.
Yeah, I've come to really like the mute button on Zoom because I'm in court a lot on Zoom, and like I just can hit the mute button and then I can shut up.
Yeah.
All right. So go ahead. So you argue it, you get the decision, and what happens?
Yeah. Well, we waited a 13 months to get the decision.
Yeah.
And that whole time, I had no idea when we were going to hear back. It was funny. My daughter came to watch me argue.
Yeah.
She was 12 still. No, 13. She just turned 13. And by the time I argued, well, she didn't really care about the argument. She was just interested in stopping at Cifelli on the way home. But by the time we got the decision, she had probably grown like 4 inches.
Wow.
It was fun. It was, when we got the decision, I started to get the sense as we waited and waited and waited that it wasn't going to take this long unless they were making new law.
Right.
If they were just going to say, just rubber stamp what the general acceptance of the pediatric community, it would not have taken that much effort to do that.
Yeah.
So they wanted to make sure they crossed their T's, out of their eyes, all that stuff. And so as the longer dragged on, the better feeling I got about what they were going to do.
So what did they do?
They ended up saying that the biomechanical community is a relevant community when it comes to general acceptance. As I said before, nobody disputed the pediatric general acceptance, but it was whether the biomechanical community should also be considered, whether general acceptance in that community is relevant to the Frye standard. And they said, yes, it is. And in large part because that's where it started.
Yeah.
And so, but because in the interim between when this case started and now, New Jersey flipped over from the Frye standard to the Daubert standard. They said, if you can do some biomechanical studies in the future or learn of some where we can have a new hearing under the Daubert standard and show the testability of the hypothesis and the results, then you can come back into court in a future case. And I don't know, practically speaking, how the state's going to do that, because you have to have a case first. You have to charge first before you can get to that hearing.
Yeah, the New Jersey Supreme Court is famous for having that culture of giving a little something to everyone in decisions like that. So that sounds like consistent with that. But so then, like, are there less shaken baby syndrome cases now in New Jersey? I guess. I mean, it's
this just came down, right?
Yeah. So it's hard to say just yet because it came down a little over a month ago.
And then what happened to your case?
So in our case, we went back into court just last week, and the prosecutor agreed they got nothing left, no other evidence other than that one opinion. So they dismissed the case with prejudice. So that case isn't coming back. I actually just got the dismissal order yesterday. So that case is dismissed now. He has that episode of his life behind him. Still,
if you can
trauma from it.
If you can say, what's it like telling your client and giving the news, and how does that if you can say in this situation or generally when you give a client good news, you know?
For this one, I told them the day before. So the court posts the day before all the appellate opinions that are coming out the next day.
Right. The lawyers find out before the public does a day before.
Well, it's on the public web. The public can find out if they know to look for it. But on the judiciary website, every 10 o'clock every day they post the opinions. I'm very much a law nerd, so I check the judiciary website every day at 10 o'clock to see what opinions are coming out.
We are too. I don't know. I didn't know it was 10 a.m. We get it at the end of the day. I have a rule. I don't know if you get it at the same time.
Yeah.
But we both read those decisions every day too.
Yeah. So then when they post the day's decision, they also post the opinions expected for release the following day. So I knew the day before that it was coming out the next day. So I told my client, I forget if I texted him or emailed him, and just said, just be prepared. We're going to get a decision tomorrow.
Did you get a little knot in your stomach or anything, or a little butterflies that you're like, ooh,
It's
yeah.
coming. Oh, yeah.
Yeah.
I mean, just seeing that. So when you're the attorney record in the case, you get it. It gets posted on the website. You also get an email. And you get that email, comes in my inbox from Supreme Court. I'm like, all right, here we go.
I know.
PDF.
It's the worst. In my opinion, it's the worst part of this job is waiting for appellate decisions and jury verdicts.
Oh, I need to go to. I usually go to a different floor of the courthouse when I'm waiting for a verdict.
So, Mark, tell everyone why you're wearing a suit today and what happened. Real quick, we're almost done here.
One of the judges you mentioned before, he's an excellent judge, Judge Buca. I tried a case in front of him back in October, and we got a good verdict. I'm happy to tell a story. There's nothing privileged about it, but it was a zero offer auto insurance case. This really nice lady got smashed into down in Florida. And it happened like 7 years ago. They offered $0. Jury took 40 minutes to deliberate, came back with a $750,000 verdict. And the defense attorney, after closing, is, the judge mistrial, and had all these reasons and basis. And Judge Buca denied it. Obviously think that was right. And then defense moved for a new trial. We had argument on that today. And, I'm always, I go to this is best case, this is worst case and all that. So I'm like thinking, oh man, if this gets granted, I'm going to be trying this case again, just right around Christmas. And Judge Buca went through, he was very thorough with the record, and he denied the motion. The only thing that was potentially problematic, he had given an excellent curative instruction for, and everything else was just kind of reaching. So
you got a $750,000 jury verdict on a case where NJM, New Jersey Manufacturers Insurance Company, was offering zero the entire time.
Yeah, and we filed something called an offer of judgment, where it essentially gives them an out where they can resolve the case for that number. And we filed an offer of judgment for $250,000, which were the policy limits, and they ignored it. They did nothing. We had an arbitration where a neutral third party evaluates the case. He put it above the policy. They just ignored that. And then all throughout the trial, it was, hey, judges asking NJM, do you guys want to talk settlement? No. And
I don't do any civil law.
Yeah.
But if you offer offering judgment at the policy limit and the carrier says no, and then they get hit for higher than that, they're on the hook for that higher number, even though it's not within the policy?
So in the UM-UIM context, if we want to get really boring, it gets molded down to the policy limits, but you get pre-judgment, post-judgment interest, you get attorney's fees, and you get costs on that. And the interest rate from the time that the offer of judgment expires or discovery ends, whichever's later, you get 8% interest. So 8% interest on a $250,000 verdict adds up quick. I think right now it's like $160 a day for every day that they're not paying it. And if it goes the route of an appeal, and say that takes another year or 2 years, it will all add up quite a bit. So that's why I'm dressed up in a suit. I was not quite a writing new law and shaking baby syndrome, but protecting a jury verdict for a really nice lady that deserves every penny of it.
That's great. Good for you.
I'm dressed like a schlub just because I feel like it. I don't know.
And actually, I'll give a shout out too. Oscar sitting over there did all the tech on that trial and was a big help. And I think when we showed up, they were looking around. The defense attorney actually asked me. He goes, "No PowerPoint or anything for this." So it was a big help. But
all right, Phil. Anything else you want to tell us about this? I mean, it's super interesting. You changed the law. You changed. And God knows how many people you helped that were wrongly accused for shaking their babies.
Yeah, I mean, it's been an issue. It's circulated through the news. We're going back decades. I think there was a nanny in Massachusetts 20, 30 years ago. That was a high-profile case. There's this guy in Texas, Robert Roberson, who's on death row.
Wow.
In a shaken baby case. There's been a lot of movement down there to try to vacate his conviction. I think he's got some hearings. That's a little different. That's not
right.
There's allegations of impact, I believe, in that case. So it's a little. I don't know that our case would directly help him, but it certainly can raise certain questions about any of the science involved. I mean, anytime that you have a guilty verdict in a criminal case based solely on expert testimony, I believe you need to really scrutinize that. Speaking of Texas, I mean, I know the one case that I'm aware of somebody who was executed on death row in a case that later turned out to be probably a wrongful conviction was a guy named Cameron Willingham. There's Netflix documentaries about him. You could look it up. But it was based upon an arson investigation and an opinion, which turned out to be junk science, real junk science, to say that it was an arson when it actually wasn't. And with no other evidence of somebody's guilt other than an opinion of somebody. I mean, experts are experts because based on training, education, experience, and all that, but they're still human beings.
Yeah.
And human beings are not infallible, and even the most experienced and well-educated academics are, in some level, just kind of, I don't want to use the word guessing, but they're inferring, they're drawing their conclusions based on their training and education, but it takes some level of a leap of faith.
Yeah.
And to convict somebody of a crime, sometimes they're right. I'm not saying they're always wrong, but you better be pretty comfortable that person knows what they're talking about, that their conclusions are based in fact, based in data, based in evidence. And in our case, it just wasn't there. And I think that it was the right decision, and I'm glad for my client. I'm glad for other clients, other defendants that are affected by it, that they're not going to have that threat out there of being convicted without any real tangible evidence.
That's awesome. So listen, when ICE knocks on my door to send me back to Ireland, and I got to call you or anyone else,
I'll take the trip to Ireland.
or if they're going to send Mark back on the Mayflower, how can we get in contact with you? And anyone that needs your help, you got a website or how can they get you?
Yeah. So the name of my law firm is Benedict Altman and Nettl. We're in New Brunswick. The website, actually, we added my last name to the firm letterhead, but we never updated the website address. So it's benedictandaltman.com.
All right. And it's Philip Nettl, N-E-T-T.
N-E-T-T-L, no E at the end. That's the Czech part of me.
Awesome.
There's no vowels in Czech Republic. But yeah, so I really appreciate you guys having me here. It's been a lot of fun.
Yeah, and thank you for standing up for the Constitution and making our state better. And, the stupid name of our podcast, Jersey Justice, but this one, your story is right in line with Jersey Justice story. So thanks a lot.
All right, happy to be here.
Thank you. Thanks for helping people navigate the Kafka-esque landscape of criminal law.